All right. Good morning again, everyone. In the midst of our murder trial, we have more calendars we need to work through. And we have this morning a plea and arraignment calendar. Oh, crap. Did I not bring out my cheat sheet? This what has already been sorted out. I will be right back. We'll get started.
Morning. Morning, Ms. Rivers. How are you? Business.
Both times. My door lead. All right. Observe my notes as to what we've already done. So, plea and arraignment calendar this morning. Position 1 is Sebastian McWell.
Yes, I'm representing Scott Forges. He's here. He told me to tell you he was in the building.
He's in the building. Is he working his way this way? Good. All right. Sit tight. Thanks. Kiera Boykin shouldn't be here. We've got a waiver. She was excused. Whose case is that?
Fine, Judge.
Hey, I'm gonna need you all to take the little guy out or gal outside while we're doing this. Like, are you on the calendar or are you here for someone on the calendar? Pardon me? Okay. Ms. Wood, your case?
This board and this mine, Judge.
Yeah. And then Falconer, Christian Falconer. Hello, Mr. Falconer. Any word from Miss Taylor? Pardon me?
She won't be joining us today. She won't be joining
I
us.
heard your words. How does that work? That's not her call to not join us.
I believe she's retiring, hiring someone else.
You're gonna hire someone else. Okay.
We found out this week last minute.
That she's retiring from the practice of law? That's news to me too. Are you getting your money back? Okay, no, I'm serious. I mean, sometimes when people leave, it's awkward and they retire on your money and don't do, I'm not saying Ms. Taylor would ever do that, but that's not gonna be an issue for you.
No.
Okay, so you are planning on retaining new counsel. Do you have someone in mind? Okay, have you had conversations with him yet?
We spoke Monday.
Okay, you just haven't retained him yet?
Yeah, they said we'll be able to make this right. They said we'll hear the hearing and then we'll have sessions tomorrow.
All right, let me. Jury is vocal. Morning, sir. Morning. We've got clothes for Mr. Tuitt. Did you already handle that?
Yeah, I'm gonna keep what you got on him.
He's good. Okay. It is what it is. I'm just looking your case up, Mr. Falconer, so we can sort this out. You're welcome. Okay, so you're saying Ms. Taylor is rolling off. You'll bring Mr. Matthews on, so we'll need to reset this. He'll need to file an entry of appearance. Ms. Taylor did that, but that was back in May of 2004, because this is 2024, because the allegations date back a little bit. And that'll, when Mr. Matthews files that entry, he'll replace Ms. Taylor. Did you get something in the mail telling you to be here?
Yes, I did, Ron. Actually, it came 3 days ago. I just called in. As I
Do you live on Sorrells Drive in Powder Springs?
did. Yes, Ron.
Okay, so we've got a good address. Obviously you'll want to give all your contact information to Mr. Matthews. He'll get notice when there are hearings as well. He won't yet. Right now, the notices will all go to Ms. Taylor. So it's good your information is current because the next time you need to come to court, I don't know that Ms. Taylor will be telling you, you need to come to
She
court.
must retire soon for health reasons, so she's not considering any cases that may take past a calendar year.
Got it. Okay. So we will reset for, and you think it'll be Mr. Matthews?
For sure, Ms. Matthews.
Okay. All right, Ms. Davis, anything on Mr. Falconer's case?
No, Your Honor.
All right, Mr. Falconer, thank you for being here. We'll look for something from Mr. Matthews and probably just loop him in when we have a new plea and arraignment date for you, since you're telling me he's the likely one. Okay, thanks. Kayla Newborn. Hello, Ms. Newborn. How are you? All right.
Good
Pardon me?
morning, Judge. I'm on the Zoom.
Hey, Ms. Golding, how are you?
Good, how are you?
All right. You filed a waiver and you and your client were excused. It's great that you're both here. But we can make this one real quick. You will be getting a scheduling order very soon that has the deadline for the state to get you discovery and when you need to file motions, but that'll all be in the scheduling order that'll go out in the next day or two.
Okay, thank you, Judge.
Ms. Newborn, do you still live on Monroe Drive? Okay, I need you to fill out they're gone. A change of address form so that we have in the system a good address for you. Your lawyer will always be letting you know when you need to be in court, but we need to make sure that the letters are getting to you in the mail as well, okay? So if you'll fill out, Ms. Simpson is bringing a piece of paper back. Once you fill that out, you're good to go, okay? All right, and Ms. Golding, thank you for plugging in. You'll get the next few court dates in that scheduling order.
Okay, thank you, Judge. Have a good day.
All right, you too.
Thank you.
So Kelvin Moses shouldn't be here. Kelvin Moses? He's in custody. Is he here? He does not need to come up because a waiver was already filed. And then he has a co-defendant, Kendra Haley, who was also excused, but who's her lawyer? Flag. Oh my gosh. All right. Rodney Brown. In custody.
He's mine, Judge. Is it possible to keep him on for the after? Are we
Yes.
gonna be able to do something?
Afternoon is going to be productive. Our jury will be deliberating in the afternoon. And so if this is one that could be resolved or you need to have more time with him, let's 100% keep him here.
Okay,
Afternoon will be back to normal.
perfect. I would like to try to resolve this today.
Okay. Deputy Gordon, can you make sure that Mr. Brown doesn't go away? All right. Emily Browning was excused. Ms. Browning, you here? Oh, okay. Same with James Rayborn. Excused. Armin Hatcher.
Hey, Dustin,
The waiver was filed on there.
Oh, it was? Okay. Just recently? It's not on your list.
Well, I didn't know, I couldn't hear if you were doing a bond on that case.
Okay, that's fine. Ms. Rios isn't around, so I'm assuming not. Okay, so waiver? Wave and is Mr. Hatcher here?
Yeah, he's here.
Okay, he does not need to come up. Or he's up.
He's up.
You brought the wrong guy up. That's all right. When you have time, he can go back down. Bradley Peoples.
Good morning, Judge. Here, Mr. Peoples, and he's present. They'll be arraigned.
Which one is Mr. Peoples? Hey, Mr. Peoples. And you are here, you work with Mr. Render? You're not Mr. Render.
No, I'm not Mr. Renner. I'm retained counsel.
Okay, well, Mr. Render was retained counsel as well, so I don't know if Mr. Peoples is, let's see.
I think it was the original attorney.
Okay,
that took over from him.
great. Well, welcome aboard. Let me see what we've got in the system. And is Mr. Peoples asking for a formal arraignment, or are you going to be waiving arraignment for him?
We have arraigned the copy.
All right, well, that's your call. We've got a waiver form that Ms. Nelson will get to you. Are you Mr. Irvin?
Yes, Your Honor, I am.
It's nice meeting you, Mr. Irvin. I'll also need you to do an entry. I've got your conflict letter in here, but the only entry is Mr. Render's, which is why he's still listed as counsel of record.
Yes, Your Honor. Was it?
So if you don't mind doing that, that would be great. And I think that's another form we've got, so you don't have to get back to a computer.
I don't know.
Mr. Peoples, while your lawyer is doing that, I want to confirm, wow, I've got an address in Savannah.
Yes, sir.
Yes, on Country Walk Circle. Okay. I appreciate you being here. You should talk with Mr. Irvin about future court appearances. If it's going to be substantive, as in we have a hearing, a witness is testifying or whatnot, you do need to be here. If it's like a status check, I am okay with virtual appearances. So you don't have to drive or fly or however you got here from Savannah. But there may be events we're working through where it's important that you be here. And Mr. Irvin may want you to be here. That's his call. But I certainly am okay if it's just a check-in for someone being on a screen. Okay. One other thing I want to check. Okay, yeah, Mr. Irvin, I think the confusion the system is having is that Mr. Render filed one of these limited entries. We don't acknowledge it as a limited entry, but back in July of last year, it says limited entry for purpose of bond. But an entry is an entry, and so he is in the system. So your entry will go on top of that, and you'll be counsel of record in the system.
Yes, Your Honor. Thank you.
Mr. Peoples, your bond order. You were supposed to stay away from a Mr. Owens. Is that something, is that person not in Savannah?
I'll let this go, honestly.
Okay, so it sounds like it's easy for you to stay away. You don't even know where this person is. Okay. No weapons, no contact. And you don't have an ankle monitor? Good, okay. Then continue to stay away from whoever Mr. Owens is, and no firearms in the household, your car, or anything like that. You should be good to go. Ms. Davis, anything from the state?
No, Your Honor.
Okay. Then Mr. Peoples, once Mr. Irvin has completed those forms, unless he has any questions or things we need to work through, then you and he are good to go. Any questions?
I just did.
That's a good place to start. All right. Natasha Scott? Are you Miss Scott? Hello, Miss Scott. Ms. Wood, your nice. Yes,
Yes, I need to get with her, get some updated contact information, Judge.
Great.
I'll follow later.
all right. Ms. Davis, your name is listed next to it, but the lead charge, oh, Here's Ms. Willingham.
It's gonna be me, Judge.
Great. All right, so Ms. Scott, I'm gonna have you take a seat. Ms. Wood, when I get through this calendar, Ms. Wood's gonna talk with you. Today may be as basic as she fills out some paperwork on your behalf and then you're good to go. I want to confirm a couple things with you. And then we may not need to talk again today, which is good because I'm gonna bring the jury out real soon. But if we need to, we will have that conversation. So we have an address for you. It says Marrow, but I assume you live in Morrow, Georgia, not like bone marrow, but Morrow. Okay, on Stratton Circle. Did you get something in the mail telling you to be here?
Yes, but it came so many days later, it was died like last week.
Okay, I think we've got the right address. And oops.
Okay, so then. This is just.
Okay, all right. You are supposed to stay away from a Deshaun Anderson. You've been doing that? Excellent. Okay, then I think we're squared away. Ms. Wood will chat with you and she has the authority to excuse you. If she says it's good to go, you don't have to wait for me to say the same thing. Okay? Thanks. Jewel Nesby was excused? Is Nesby? Okay. Barbara Joyner. Wow, I have nothing listed on this one. From her?
It was she was calling like chambers,
Ms. Joyner was.
yes.
Hmm.
But I turned.
Okay. Ms. Wood, is this a case that'll be running through your office? Hard to know?
I'm checking on that now, Judge.
Me too.
I have a number for you to call for.
Okay.
Yeah, it's been a minute. It's like a year after the arrest, but the charges are.
Who's that would be,
Ms. Willingham, will this be your case?
position 415 on the census.
Ms. Nix, she's on the call.
Yes, sir.
Good
This is
morning,
my
Ms. Nix. How are you?
judge. I'm well. How are you?
All right, so you have position 14, Ms. Joyner?
Yes, sir.
All right. Trying to find. Here's your bond. All right, well, she has a bond. I guess Ms. Wood will pass her contact information along. And what I'm gonna do is say bench warrant question mark. She's made some outreach, and if you can confirm all that, and maybe she's waiving arraignment, let Ms. Nelson copy Ms. Nix know. And I'm gonna hold off on the bench warrant for a few days, so you can see what you can sort out.
Perfect, thank you, Judge.
Judge, I'll request that one be prepared and sent to you, just so that I don't forget. And then I'll just leave it up to Your Honor to sign it.
Yes, no, please do that. Get the bench warrant sent over here. I won't sign anything for a couple days. We'll see if Ms. Joyner meaningfully connects with Ms. Wood. This will technically be a Rios case?
Yes.
Okay. All right. And then finally, we've got Robert Brown, position. Oh, he should be in custody and we're working through, this should be your case also, Ms. Nix.
Yes, sir.
Okay. Why don't, and it's a 4. So this is your case, Ms. Wood? Have you met Mr. Brown before or he missed plea and arraignment?
Yes, he missed the arraignment.
Should we do him this afternoon?
Yes.
Okay, Ms. Nix, I hate to do this to you, but maybe you can convince someone to cover it for you. We have a 1:30 calendar today, and that one will be in the midst of jury deliberations, hopefully. And we'll be able to get much more substantive about things. We'll bring Mr. Brown up. Ms. Wood can talk with him and then talk with you, whether it's a case that can be resolved, or are we setting aside the bench warrant, or is he staying right where he is? Are you able to rejoin us around 1:30?
I already planned on being there, Judge.
I like that. Okay. So this is you, not Ms. Clark. And that's the calendar. Mr. Fortis, good morning. Mr. McWell is here. He told us you were in the building and we're working your way here. Are you doing a waiver?
We already did, Your Honor. I think the confusion was when I originally handled this bond matter, I had not been retained for the case. I subsequently after that was retained for the case and we did file our entry waiver and motions that were accepted.
Okay, so you're in for the long haul. You've done a waiver. We'll get a scheduling order. Ms. Davis will get discovery to you. And Mr. McWell, you hold on. We live on Stone Road, apartment E15. Excellent, that's good. And now that you are out, let me make sure we're clear. What's going on with bond? Oh, you gotta live there. That's in your bond. You're staying away from a bunch of people. You've got a curfew, so you should have ankle monitor on. Excellent. Mr. Fortis, anything else?
No, Your Honor, that does.
All right, you'll get the scheduling order and we will see you and Mr. McWell whenever is the next time, a motions hearing, final plea, whatever it is.
Thank you, Judge. Good to see you.
Staying. So Rodney Brown we'll deal with this afternoon and Robert Brown will deal with this afternoon.
Mr. Can I have one more request of the court?
Yeah.
It's an off-calendar matter very briefly. Crystal Alexander is from the September 25th trial calendar. She missed it today. Mr. Goss covered for me. She's here. I'm gonna speak with her and.
Which one is Ms. Alexander? Hey, Ms. Alexander. Oh, right, we had a trial calendar. She's got a bench warrant.
Yes.
Okay,
I'm gonna speak with Ms. Davis, Ms. Alexander, see if this is also something we might be able to handle this afternoon.
great.
Yes.
Okay, thank you.
Thank you, Judge.
So Ms. Alexander's not free to leave as long as she knows that.
Understood, Judge.
Okay, all right, thanks for being here. Anyone here who thought they were on a calendar this morning and didn't hear their name called? Nope. Then let's pivot. Can we bring Mr. Tuitt, 1:30? We'll see you at 1:30. Excellent. Can we bring Mr. Tuitt out, please? I don't know.
Oh, they're gonna orange chicken.
Yeah, well, she's got a bench warrant. Yeah. I don't know how you want to manage Ms. Alexander. I don't know. She has a bench warrant. It's valid. I signed it. I don't mean for her to go in there if they're working the case out, but she also needs to not walk away. So how do you want to?
That's all.
You're okay. You're gonna give her the something, something? All right,
Yes.
we can do it. Okay. Your credit card or mine? Good.
We give them the only pizza option, because it's too much to try to
Mm.
sandwiches.
No. Right. Okay. I'll bring that up.
Okay.
Mr. Abadi, since you are standing, can you come get one copy for the state, one for the defense, the final jury charge? Reflects our discussions from yesterday.
So, I'm this is better, this is what you want, so it's. Okay.
All right, we're gonna get back on the record. Ms. Rivers, you ready to go? All right, good morning, everyone. This is day 4 of Mr. Tuitt's trial. Mr. Tuitt is out here with his lawyer. We've got our prosecutors. We've got all our jurors. And it's time to get rolling. Ms. Fagan, as I'm remembering when we left off yesterday, we are going to bring the jury out. I will ask you to call your first witness, and you'll say you're going to rest. I think what's going to happen, and we'll go straight into closings, which will be state, defense, state. Anything from the defense before the jurors come out?
Yeah.
Get your 82 slides ready to go?
Yes.
Okay. Good morning, Mr. Abadi. How are you doing?
Morning, good. Thank you. How are you?
I'm all right. Are you ready to go?
Yes, sir.
Anything from the state before the jurors come out?
There you go.
Do you have a thumb drive that has all of the videos other than Mr. Tuitt's statement to the police?
Yes, Your Honor.
Great. And did you and Ms. Fagan talk about what exhibits go back with the jury and what don't?
Not yet, but I think we can be quick.
Okay. I think it's not a complicated one, but I just sometimes, oh, it's 30 minutes because what about this? I don't think that's this case, and I don't think it's these lawyers. All right, let's bring the jurors in, please. It's like interesting when a lawyer who's never been in here before. I'm understanding what you're saying. I'm the one.
All right, for the jury.
Give me your name. To look it up.
You're the president of the county board?
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. Happy Thursday. Appreciate you all being on time. We took care of a couple calendars while you were doing whatever you were doing, not doing any outside research. We're talking about the case. I've got some good news and some great news. The good news is we remain on schedule. The great news is lunch is on us today. Lunch is going to be pizza. There'll be vegetarian pizza, non-vegetarian pizza, but that's designed to maximize your productivity today. So you don't have to go away for lunch. So we'll be taking care of that. We're going to get going. Where we left off yesterday was Mr. Abate had announced on behalf of the state that the state had rested. So they presented their case in chief. I needed to work through a number of things with the lawyers. We've done that after you left yesterday. And so now I'm going to ask Ms. Fagan if the defense is going to present any evidence. Before I do that, reminder, there is no burden on the defense. And so an answer of, nope, we're good, or whatever the words are to that effect, is unremarkable. There is no burden on the defense to come forward with any evidence or to call any witnesses at all. They have the right and the ability to do so. So if they want to, they can, but they may not. With that, Ms. Fagan, would you call your first witness?
Your Honor, at this time, defense rests.
Okay. Now the evidence is really, really closed. The defense has elected not to present any evidence of its own beyond whatever evidence may have been presented through cross-examination, et cetera. And so we've reached the point where the lawyers have an opportunity to present their closing arguments or summations. These are efforts to persuade you to decide the case in one direction or the other. And it is perfectly appropriate to feel persuaded. These are advocates and they're effective at what they do. Keep in mind this, however, You decide what the evidence is. A lawyer telling you 6 times and putting up 2 slides saying this is what the evidence is doesn't make it so. You decide what the witness has said and what that testimony means. But there's nothing wrong with the lawyers helping you put the many pieces together and for you to say, aha, now I understand it better based on what you shared with me. So the lawyers are free to do that and you're free to be persuaded. But the evidence is witness testimony and exhibits that were admitted. When the lawyers are done, I will give you the law that you must apply to the facts as you find them to be. Because the state has the burden of proof, they have the ability, the right to open and close with closing argument. So I suspect in a minute, one of the lawyers is going to talk to you for a while about the facts, maybe about the law, and sit down. And then Ms. Fagan will have an opportunity, and then the state gets to rebut, have that last word that you're going to hear from the lawyers about what this case is about. Okay? So if the state would begin its closing presentation. You're welcome.
Good morning, ladies and gentlemen. I want to begin by thanking each and every one of you for a long process. Started last week, trailing into this week. We've made it to the 1 week mark. I have seen you all take notes, pay attention, ask additional questions of the witnesses, and do the job that we kept asking you. Could you be fair and impartial? Because that's all that we ask. Now, you're going to hear more today about the evidence from Mr. Abadi, from Ms. Bacon. But I want to talk about the law that applies to this case. And the judge is going to give you a copy of the law, so you'll have that to take back with you. But I want to talk through the law that applies, the law that just simply doesn't, and how the facts weave in to show that this defendant is guilty of each and every charge that is listed in that indictment that you will have in the back. Chest, neck, hand, shoulder, abdomen, back. 6 shots that were fired into Bratavius Wright. Starting with press contact wound. The muzzle still embedded in his chest. That is nothing short of murder. Simply put. But I will walk through how we get there. So let's talk about the law. You all have that duty, as we have stated, to be a fair and impartial juror. And what that means is that you are honestly seeking the truth of what happened early that afternoon, back in 2022. That's it. You are not to seek doubt. You're not to seek some odd possibility, but the truth of what happened that day. The judge, as I stated, will give you the law. He will read it to you, give you a copy to take back there with you. You are bound to follow that law. And you are bound by your duty to deliberate, each and every one of you. And so if you get to the back and somebody refuses to participate, please send a note out and let the judge know. It's your duty. Now, a way I like to take or talk about what you do in the back there is when you enter that room, you leave certain things outside that door and you use certain tools inside.
I'm going to pause you for 1 second. You've done nothing wrong. I'm wondering if there is a way to share what's on our screen is this funky
I'm so sorry.
preview. the important folks are able to see what's going on. The big screens are showing that. And if we can't do it, then don't worry about it. But thank you, sir.
No.
There you go.
Did that work? I'm
Oh,
sorry.
no.
No. We're gonna do it. Wait.
It's not critical. More important is that the big screens are showing it.
Is that working on both screens? All right.
Amen. Thank you. I'm sorry for interrupting.
That's all right. I double as IT, so no problem. Now, as we were saying, what we ask is that you leave outside that room everything that's on the outside of the circle. Any passion that you have, any public opinion about crime, about the police, unhappiness with the police, public feeling on a certain subject matter, any sentiment, one way or the other. Sympathy, disagreement with the law, you are bound to follow the instructions of what is written. Conjecture, any thought of penalty and punishment that is not for you to decide, and any prejudice that lies on your mind. For or against a person, for or against a thing, it is about the law. It is about actions. It is about the crime. You have heard through the course of the trial. We even try to make sure that we embed that into everything that we're doing, leaving any prejudice, any differentiation out of the equation. I will refer to Mr. Tuitt as Mr. Tuitt or the defendant. Mr. Wright gets called Mr. Wright or the victim. Quatavius, Tay. Not by smoke. I'm not talking about him on stage. We give him that respect. We give everybody that respect because we're here about actions, not a person. We're here about actions, and the actions that are criminal, the actions that have led us into this courtroom, and the actions for which you must make the decision of the truth of what happened that day. So we ask that you leave all that outside and take in there what's inside of the circle. Again, a copy of the law, we'll have that from the judge. The testimony that you heard from the experts. You heard Ms. Hallman from the GBI testify that all 6 shell casings came from the same gun, and it was not the pink gun that Mr. Wright had. There was no evidence to show or indicate that that gun had been fired. But there were 6 shell casings, spent shell casings collected from the scene. And then you heard from Dr. Hebert, 6 shots to Mr. Wright. And I'm sorry that you all had to go through and look at some gruesome photos. But I think over time, unfortunately, we have become desensitized to what murder is, to what homicide is, to what death looks like. And we're here because a death was unnecessary. It was senseless. You heard that multiple times. And so we have to show you exactly what that looked like. The excessiveness of shooting someone 6 times while you're mere feet away, if we can even say that far. But it's important because that's evidence that you take back in the room with you. You will have a copy of photos. You will have a copy of the video. You're able to play it yourselves and review it. the elements of the crimes, and we'll talk about that a little bit. And then your common sense. That's the most important tool you have back there. What makes sense of what happened? What makes sense from what you heard? The witnesses that said, I knew this, I didn't know that. I saw this, I didn't see that. What makes sense? Now, the burden of proof. The state is the only one that holds a burden, and it is to prove the case beyond a reasonable doubt. That is not proof beyond all doubt, not proof to a mathematical certainty, a certain percentage. It is not a vague or arbitrary doubt that we're looking for. It's a reasonable doubt. And that's explained pretty plainly. The doubt of a fair-minded, impartial juror honestly seeking the truth, not seeking doubt, but seeking the truth of what happened. What does your common sense and reason tell you? And if it is beyond a reasonable doubt that he committed these crimes, then we have met our burden. Now, when I have free time, which is not very often these days, but I like to do puzzles. And you open up a puzzle, you get a box, and on the front is a picture. So you know what it's supposed to look like, but you open up the box and there's nothing but a bunch of pieces. So you start, the strategy usually is to get your corners together and then work your way in. Now, in the process of putting this puzzle together, I don't have every single piece. I cannot tell you beyond all doubt what this is. But I can look and I can see $1 at the bottom. I can see the name Washington. And I can see a gentleman in the middle who looks a lot like George to me. So I can tell you beyond a reasonable doubt that the puzzle is of a $1 bill. I can't tell you beyond all doubt, but beyond a reasonable doubt. That is our burden. Now, the presumption of innocence, the way I like to think about that is kind of like a cloak, a coat, really. I guess we're going to the fall. So when the defendant entered in, beginning of this trial, he was presumed innocent. He was wearing that heavy winter coat. However, as the evidence was presented during the course of the trial, it turned the heat up in the room. Got a little warmer. And as the heat went up, that coat came off. We met our burden. It overcame the presumption of innocence. And at the point that the state rested, he was proven guilty. That coat was off. Though he began presumed innocent, the evidence is clear that he is guilty. And you have two types of evidence that you can consider when you are making your final decision in this case. Direct and circumstantial evidence. Direct evidence. That's something tangible. It can be seen or heard, sensed in some way, smell, taste, touch. When you hear Mr. Forte say, man, he didn't even have a chance to go for it. He didn't have a chance to get to the gun. Because all I heard was the shots. It was a bunch of shots. And I took off running. When you see the photographs of Mr. Wright's body, when you see the shell casings, you'll have them in the back. 6 that match from the same gun, that gun not being the pink gun from Mr. Wright. And when you look at the video and look at the positions of Mr. Wright up against, I think Ms. Park said it's either a door or a wall, but it sure isn't an open way to get out. And you see the defendant advancing towards him until the final moments where that gun is pressed to his chest, and then we see him fall. We see him fall. That is all direct evidence. But there's also circumstantial evidence. I'm gonna apologize, I use a lot of analogies, but that's how I like to think about things. So circumstantial evidence is a little different. It is proof of facts or circumstances by direct evidence, using that direct evidence to infer other facts that are connected, but reasonable and justified in light of experiences and common sense. So I think of that with an activity I had to do this morning while rushing here. I should have done it last night. It never happens that way. But getting gas, because I was on E. So I knew I needed gas because a little orange light comes on. I see the little lever in my car is down by E. The mileage, it says 2 miles till empty. And so at that point, I know I need to pull into the gas station, pull up to a pump, turn my car off, put my card in, take out that handle, put it into my gas tank, hold for the lever, watch the numbers continue to go up. For me, go up for a while. And then I feel a click. And at that point, I take it out, put it back in the pump, get my car turned on and drive off. Now, I never actually saw gas flowing into my gas tank. It's impossible to see. But when I got back into the car after feeling the second click, orange light was off, lever in my car is up by F instead of E, and I was able to make it here, because I can tell you it's more than 2 miles. That is circumstantial evidence that led me, beyond a reasonable doubt, to a conclusion that was reasonable with common sense. That's how circumstantial evidence works. And what weight you deem between direct and circumstantial evidence in proving or getting to a certain fact is completely up to you. That's your decision. It can be entirely on circumstantial evidence. It can be entirely on the body language in the video, the positioning of the two. It can be based on someone who saw it with their own eyes saying, only one person shot, the other one did not have his hand on the gun. Moved it, but never touched it again, and that was minutes before the shots were fired. What you deem the most credible, what you give the most weight in making your decision, completely up to you all. You have witness testimony, exhibits, videos, photos, documents, all at your disposal. And when we're talking about testimonies, I want you to know that the testimony of a single witness, if believed, is enough to establish a fact. That's it. If you find Mr. Forte credible, if his recitation of the events with no motivation, his only connection was to Mr. Tuitt. He didn't even know Mr. Wright's name. Old dude. Miss Forte, she told you. I mean, I care about CT too. I thought, okay, he was talking about it like he said self-defense, but then he told me it was 6, 7, I think she said 6, 7 times. Her reaction, excuse my language, oh shit. Because that's not self-defense. But their testimony alone is enough to establish a fact. You do not need corroboration from any other source legally. But here you have it. In determining the credibility of any witness, whether it's a lay witness, Ms. Forte, whether it's Ms. Parks, whether it's Ms. James, or whether it's the experts, you are able to look at many different factors, including the nature of the facts they testified to, their means and opportunity for knowing those facts. Ms. James came in here. She told you what she saw and what she didn't see. She was right there in the car, and somehow the two kept missing each other. It seems Really? You're there? You all didn't see each other? But then we watch the videos showing Mr. Wright come down the stairs after she had gone to the car. But he's at the other end of the building. She then goes back up on the elevator, but he's coming around the side. He stops at the car and talks to her daughter, and then comes back in and goes up the first set of stairs, or those set of stairs that are on the edge, but she took the elevator coming back down. Think about that. And her connection is to Mr. Wright. What motivation does she have to say anything different than what she said? And that applies to all of the witnesses. You determine their personal credibility as you observe it. It is entirely up to you. So now let's talk about the charges in the indictment. You have 8 different charges to consider. 1 count of murder, also referred to as malice murder, we'll talk about that. 3 counts of felony murder. 1 count of aggravated assault with a deadly weapon. 1 count of possession of a firearm during the commission of a felony. And you technically have 2 counts of possession of a firearm by a convicted felon, but counts 7 and 8 are slightly different. So you'll see possession of a firearm by a convicted felon on the indictment, but the definition for count 8 is different than count 7. Count 8 is based on use of a firearm by a convicted felon during the commission of a felony, and we'll talk through that. For each and every crime, intent is an essential element. And it must be proved beyond a reasonable doubt. But it is not an intent to say, hey, you know what I'm going to do this morning? Break some laws. I think that's what I have my mind set on. It doesn't work that way. It is the intent to commit the act that is criminal. The intent to pull a trigger. The intent to have that firearm knowing you're a convicted felon. The intent to use it against the law, then to fire 6 shots into someone. The intent to make those decisions. And it can be implied. It does not have to be stated to someone. Someone doesn't have to say, that's what he said, is that he was going to pull a trigger today. No. It can be implied by the actions. And I think that's what you have seen time and time again. So count 1, murder. A person commits the offense of murder when that person unlawfully and with what is called malice aforethought causes the death of another human being. Malice aforethought, long word, but let's break down. What it means is not ill will or hatred. That's not what's required to have malice. It is just the unlawful intention to kill someone without justification, without excuse, and without mitigation. We'll talk through justification, but I submit to you, this was not justified. Excuse, we didn't hear that. Ms. Tuitt said he was inside. The officers asked him. And mitigation, didn't hear it. So we know those don't fly. Malice can be either expressed, meaning you had a deliberate intention to kill, or it can be implied from the very nature of the actions, meaning there was no considerable provocation and all of the circumstances surrounding how that killing happened show an abandoned and malignant heart, which is a complete disregard for human life. You all saw how bloody that scene was. The muzzle was pressed into his chest before he fired the first shot. And then he went 5 more times. Really 4. And then the last one to the back. You heard from Dr. Hebert that Mr. Wright was paralyzed. And you can see in the video as he tries to bring himself up on the rail with that last bit of adrenaline he has rushing through his body. He's not able to move his legs. There was no threat. And this all happened over disrespect. That is a complete disregard for a human life. It was not necessary. And I know a lot of people see murder and think premeditated murder versus premeditated murder. That is not required. Premeditation is not required under Georgia law. It does not have to be that you plan to do this. It just has to mean that malice existed at the time you pull that trigger, and malice can be formed like that. The second you decide to do it, malice is present. But think how many times we have it. If that's not malice, I don't know what is. Motive. Now you've heard some testimony as regards to whether this was about a dispute about what the defendant had been doing with Ms. Parks or Roxy, and whether or not he was upset that Mr. Wright had said, hey, you cheating on your girl. You know what it wasn't? Anything that justifies murder. So yes, we provide evidence. We provide everything as it comes out. Facts as they come from the witnesses as they are. But you do not have to be 100% decided that, yes, we believe that was the motive. Motive is not required evidentiary-wise and legally. It is not required. Proof of motive is not required. But we present the evidence because we tell you the whole story. That's how you get to the truth. That's it. But it goes to the defendant's state of mind at the time. Are you upset? Are you angry? Pissed off because somebody tried you? That's not self-defense. That's what shows it's murder. Now counts 2 and 4, or 2, 3, and 4, excuse me, are felony murder, different from malice murder, because malice aforethought is not required for felony murder. This is where a person commits a crime that is a felony during the commission of the murder. And as long as there is some connection between the homicide and the felony being committed, that individual is guilty of felony murder. All you need is the intent not to murder, but the intent to commit the underlying felony. You do not have to intend to kill someone, but did you intend any of the bases? In this case, count 2 of felony murder is that Mr. Tuitt intended to shoot Mr. Wright with a firearm multiple times. And because he intended to do so, and Mr. Wright died from that action, he is guilty of felony murder under count 2. Count 3, possession of a firearm by a convicted felon. Because he possessed a firearm as a convicted felon, and then Mr. Wright died while he was in the process of that, he is guilty of felony murder under count 3. Count 4, he used a firearm, fired it, not only possessed it, but fired it while committing that aggravated assault against Mr. Wright. Because of that, he is guilty of felony murder under use of a firearm by a convicted felon during commission of a crime in count 4. Now count 5, aggravated assault with a deadly weapon. That is when someone at least attempts to commit a violent injury to another. An assault was made with a deadly weapon here, and it's not required that actual injury be shown actually with aggravated assault, but here you have it. You've seen it. A firearm by definition is a deadly weapon, right? As a matter of law. We saw the handgun. We do not have to question that part. Shooting Quintavious with a handgun is an aggravated assault committed with a deadly weapon. Count 6, possession of a firearm during the commission of a felony. That one breaks down pretty easy. When a person has on or within arm's reach In the pocket or just in the hand as a firearm? A firearm during the commission of a felony crime. Murder, felony murder, aggravated assault, all felony crimes. If you find that he possessed a firearm in commission of any of them, that constitutes possession of a firearm during commission of a felony. Possession of a firearm by a convicted felon. This is count 7. This one was the defendant convicted of a felony. You know that from State's Exhibit 140, tendered in right before arrested yesterday. It is a 2019 felony conviction out of the Superior Court of Cherokee County. That means in 2019, he was a convicted felon, and on this day in 2022, he possessed a firearm. You saw it? Time and time again. Count 8. Use of a firearm by a convicted felon during the commission of a felony. It's kind of a combination when we think of count 6 and 7. So did you have on pockets or in your hand or within arm's reach a firearm during the commission of a felony against another person? Murder, felony murder, aggravated assault, all constitutes felonies against another person. After having been convicted of a qualifying felony. This was the second document that was tendered in before we rested. It was a prior conviction out of Fulton County that is referenced in count 8, and that is a qualifying felony. If you find that he met these prongs on that day in August in 2022, he is guilty of use of a firearm by a convicted felon during the commission of a felony. Now, you heard evidence from Ms. Parks, from the fugitive unit about some of the conduct of the defendant after all this happened. Because our video ends as we see them run past Miss James's car, take off towards Donald Lee Holloway. You heard Ms. Forte say, hey, I went my own way. I didn't see him again after that. I heard him, but I didn't see him after that. But then you found out about what he did. He hid out in a hotel for a while with Miss Parks. This is as he's calling everybody, calling Miss Forte, saying, man, I'm gonna turn myself in. Self-defense. I mean, I shot him 7, 8 times, 6, 7 times. I'm gonna turn myself in. Actions, words, and conduct of the defendant that reflect to you that the defendant has a conscience, indicating a guilty mind, can be considered evidence of consciousness of guilt. The actions before, during, and after this crime all go to show that Mr. Tuitt is guilty. He flees the scene. He doesn't return home. He's active on that phone as he's changing numbers. Hides out in the hotel. And then when he's finally placed under arrest, decides freely and voluntarily, I'm going to talk to the detective. But I didn't shoot. I don't know what you're talking about. I was inside. I was in my apartment. I heard some shots. He actually tried to say, LaQuentin Forte, I mean, he was outside smoking. But me, I was in the apartment. And then even when she tells him, we have video. Show it to me then. Because I didn't even talk to old dude. Didn't even talk to Mr. Wright. Didn't even do it. But here we are, years later. And this is where we're talking about something. Okay. Let's talk about self-defense. See, self-defense legally was carefully crafted in the law because it should not be easy to take a life and walk away. You shouldn't. There are steps, hurdles that you have to overcome to say, this indeed was a justified killing. Was it reasonable? Was it necessary? What were you protecting against? Why did you do it? And was it excessive? Because at each and every one of those steps, we start at murder, we end up at murder after step 1, after step 2, after step 3, after step 4. Only after all 5 steps here are complete do we find self-defense up at that corner. We didn't make it in this case. I can tell you that. But let's talk about why. Deadly force is justified only if a person reasonably believes that deadly force is necessary to prevent their death or great bodily injury. If you're the one holding a gun to someone's chest, pressed up against it, you got a hard time explaining to me how it was necessary to prevent your death, not theirs, but your death, in that moment to fire 6 shots. Did we make it up these 3 steps? I would say no. And it's important that it is not what the defendant thought in the moment, but a reasonable person in the same set of circumstances. And you kind of got to look at that because we had somebody else who was with Mr. Tuitt, who was present, who you heard from. And when Mr. Tuitt told you, he said it wasn't necessary. He called it stupid and said it was senseless. And no matter how many times Mr. Fagan said, but he had the gun in his hand, no, I didn't say that. You see it right there on the video. No, he didn't have the gun. Why did Mr. Tuitt shoot him? Why did he shoot Quatavius? He told you. It wasn't because he was scared. It wasn't because he said, oh my gosh, my life was on the line. He said he tried me. He tried me. But disrespect is not justification. That does not constitute self-defense. You cannot be influenced by revenge or anger for what he said to your girl that you just didn't like. Or when you tried to step to him the first time, he said, I don't care. Or he didn't give you the level of respect I guess you thought you wanted. Disrespect, ego, that only gets you to murder. There was no evidence presented that Cordera Tuitt operated out of fear. Not at any point, not in any of the conversations, because you can throw a word around as much as you want to. Self-defense, self-defense. You can say it was self-defense. You can say he reached for the gun. You can say you see the gun in his hand on the video. You can say he was just a threat for being on his own floor at his apartment. Why? Because his name? His nickname? All you heard was evidence of anger, maybe evidence of revenge, evidence of disrespect. But if it was not fear, if you did not hear a single person say he shot because that's all he could do because Mr. Wright was going to take his life, didn't hear it a single time. And that's how self-defense doesn't even apply to this case. Even in a case, though, where we have actions that are deemed, okay, we're in the self-defense realm. We don't stop the analysis there. Because the law requires that you assess the situation to say, Was the force necessary or was it excessive? So that's that final hurdle. Because use of excessive or unlawful force while acting in self-defense is still not justified. It's not. If the force that was used exceeds what is necessary to stop a threat, then you are still guilty. That's the difference. He made it clear. We see the video, but then we hear from somebody who was there. The only one with the gun in their hand, Tuitt. Only one who takes it out and points it, Tuitt. Only one who fires any shots, Tuitt. And he fires not one press contact wound to the chest. And I want to be clear. Dr. Mayberry made it clear, we don't necessarily put it in a certain order, which is true, but when we see a press contact wound to the chest, that had to be the first shot. In a series of 5 more, but he was able to put it up, point it, press it into him, and then pull the trigger. That means the trigger was not pulled until it was in contact with the skin. That alone, I submit to you, would be excessive. But continuing 5 more times. And you'll see the video again. Pay attention to, we have the shots, we see him run off, he comes back. Before grabbing something, grabbing the bag, and then leaving. If that is not excessive, I don't know what is. Whether you find that the first, second, third, fourth, fifth, or sixth shot was the point at which it got excessive, we get there. And when it is excessive force, it is not self-defense. It is not a justified killing, and Mr. Tuitt is guilty of murder. That's just where we are. When the force exceeds what is needed for self-defense, even in a case where they found that self-defense was there, at the point at which that force is excessive, you're now the aggressor. And you're guilty. We did not make it past the step of a reasonable belief. It was not necessary to shoot him at all. Police were downstairs. It was not necessary to prevent death or great bodily injury because he didn't even have the gun in his hand. You have a hard time convincing me he had the gun in his hand and yet didn't get a single shot off during that process. Circumstantial evidence that proves it back. We did not get past the step that this was not motivated by anger or revenge. Never left there. And we cannot look at those photos, see that body of Mr. Wright riddled with bullets, and say that it was not excessive. We are at murder every step of the way. Now you're going to hear from Ms. Fagan, who's going to go through and give her closing arguments, and then at the end, Mr. Abadi is going to come before you all and go back through the evidence that ties into this law, the evidence that shows beyond a reasonable doubt that Mr. Tuitt is guilty, that this was nothing short of murder, and that he must be held accountable. I would ask that at the conclusion of this, you find the truth of what happened that day and find him guilty on each and every count. Thank you.
Thank you, Ms. Jones-Connor. Ms. Fagan, if you want to transition the technology to your device.
Good morning, everyone.
First and foremost, I want to thank you all for being here. Just like the state said, I have also noticed you take notes. I've noticed you be super attentive and listen to the evidence and look at the exhibits that have been provided to you. From the beginning, I told you that we felt that we found what we needed in you. We found people that would be fair and impartial. We found people that would listen to all the evidence, apply the law, and seek the truth. And that's what we're looking for. Each and every one of you were specifically chosen because of experiences that you've had and things that you shared with us during jury selection. Ladies and gentlemen, this case is about applying the facts to the law to seek the truth. And I've been repetitive, but I'm the only one that is consistently like, watch the video. You just spent almost an hour listening to the state and not shown any of the actual evidence. You heard the story, you hear what sounds good, but this isn't about your feelings, it's about the facts. And so this isn't about puzzles, this isn't about gas. There's other analogies the state uses about whether or not the rain was falling and we don't know because there's no windows in here, or whether or not, so these are analogies that are used consistently to persuade people of our community to just not look at what the evidence is in this case. Ladies and gentlemen, if you recall, I was the first one to show you the video in this case because I want this case to be about the facts, not what sounds good, but the facts. Ladies and gentlemen, first, we have to apply those facts, then we'll talk about the law. Ultimately, we're asking you to simply seek the truth. But to seek the truth, you have to look at the big picture. The state harps on 6 shots. Harps on 6 shots as excessive force. But what's the big picture in this case that you know? This was a situation that lasted over 30 minutes. This was a situation that smoke came to the stairwell without a firearm at that time. You couldn't see it. But on his way back, 5 minutes later, you saw his pink firearm. What you noticed in the video, the compilation that the state showed you, was that after that 5-minute confrontation, he went back to his apartment, he went down the elevator, he went around the building, he came back from around the building, he went in through the same door that the elevator was located, walked underneath to come back up the stairs, to then start his second confrontation. Now, granted, Mr. Forte and my client might not be friends anymore. Granted, he felt like he needed to clear his name. But the reality is what he consistently told you was that Smoke was the aggressor. That Smoke was the one that started this. Ladies and gentlemen, in those 2 arguments, those 2 5-minute, the lead detective called it heated debates. In those 10 minutes, if my client wanted this to be a murder, wanted this to be a shooting, he had 10 minutes to do so. But that's not what this case was about. This case was about that Smoke would not stop. It was not going to stop. I see that the conversation went more like, yo, you're tripping. 12's outside. Calm down, you're tripping. And the response was, I don't give a fuck about the police. That's more realistic to the big picture. Because, ladies and gentlemen, this isn't John's Creek, this is Bankhead. This is August in the middle of the day, in the middle of the heat. Ladies and gentlemen, the big picture is what you know, who you know, and how you know them. Many people that move into Fulton County don't even know where Bankhead is. They don't know who lives there. They don't understand what those people have been through. Ladies and gentlemen, this is about what you know, then who you know. So the people that the state brought in, remember, the detective didn't even look to see about those 2 individuals you see on the video walking through the confrontation. They did all that work. They have all these videos. You didn't just go look to see what apartment they went into to just talk to them to see what they knew. Instead, what we have here is they brought Miss James, who indicates to you that this was her firearm, but she doesn't know what type of gun it is, doesn't know where he carries it, that she doesn't even know Mr. Tuitt and doesn't even know Miss Parks. And then you have Miss Parks come in and talk about some picture on Smoke's phone. And what's interesting about that is that Smoke and my client must have had some type of relationship to be that close to show a picture. But Miss James says, well, she doesn't even know them. Miss Parks says, well, I've known him. First it was Tay, and then it turned to Smoke. My client's always been CT. But what the evidence showed in this case was that Ms. Parks came in here, indicated that she moved into this apartment in March. A couple months later, her lights were off. She has a dispute with my client about it. Then 6 months later, the shooting happens. But my client doesn't go to his front door. My client doesn't follow him when he leaves. It was over. What the evidence showed in this case, when Mr. Forte told you, was that they had been gambling that night. He said that they didn't get home until 6, 7 in the morning, that they were going to the mall because they hit. They were in a good mood. They woke up, they were just about to go smoke a cigarette. And then all of this happened. Ladies and gentlemen, the state doesn't need to prove motive. They don't need to prove meditation. But that video shows the motive and premeditation of smoke. This didn't have to happen. This didn't have to happen. But my client didn't start it. And that's not fair. So, ladies and gentlemen, the big picture, what you know, who you know, and how you know. That's what this case is about. Ladies and gentlemen, the big picture, when and where you know this information, but why? Now, and then the state brings up the Ring camera. And if you look at the Ring camera, when Miss James took the stand and she said she recognizes the voices, if you look at the video compilation, at that time, 12:43 p.m., that's what time he was outside walking around the building. That's the evidence that you have in this case. So, ladies and gentlemen, let's talk about the big picture, how this all starts. Smokes leaves his apartment and heads to the stairs. That's what we know first and foremost. This is the video, so you will have all the videos in the back. So I won't sit here and I won't drag it out. I know that you understand my argument, but I just want to highlight a couple points, okay? This is when he initially leaves the apartment. And what you see is that when he leaves, he has his left hand, and this is important, his left hand is in his pants, but you don't see the pink gun in his waistband at this time. He has no cigarettes. Now, what we know is he stays down in that stairwell for 5 minutes at that point. There is a 5-minute discussion, and after that 5 minutes, no gun was in sight there, 5 minutes later, now he has a firearm. So something happened on that stairwell where he, at that point, produced a firearm, 30 minutes before the shooting even occurs. So you want to talk about excessive force and motive and what his intent was? His intent was to sit on that stairwell and smoke a cigarette. Not for this gentleman to come from his apartment, have some kind of confrontation, who knows what it was about. But what you know is whatever happened caused that man to, at that point, pull his gun and put it in his waistband. At that point, he made it known, I'm armed. Ladies and gentlemen, and so the reason I have the red circles here is because later, when the shooting occurs and I argue about his right arm, what you'll see in this moment and the way is how he fixes his gun when he finally walks down the hall. Because this is the same body language you see during the shooting. And at that point, that's when he's fixing his gun. And so his gun, you understand that it's to the right. Now, 20 minutes later, right? Now, my client's still just sitting smoking cigarettes at this point. You never see my client moving in and out. You never see him trying to go find smoke. You never see him just trying to start any more confrontation. Instead, smoke goes around and you see him, we saw this video, and then this was the first video that I showed you. And the only purpose of this video is to simply show how long that confrontation was. How long, and the fact that it would not stop. It would not stop. Smoke was not leaving the confrontation that he started. So it's for 5 minutes. And this is how it starts. And you know, on behalf of Mr. Tuitt, what you'll hear from the judge is that there's no duty to retreat in Georgia. You don't have to leave in a scary type of situation. But the reality is, when Mr. Tuitt's going up the stairs and Mr. Wright's following him, the only place Mr. Tuitt has to go is back into his apartment. That's his only option here. This is the 2nd minute. This is the 3rd minute. And I mean, nobody even tried to talk to these people. But Mr. Forte told you that there were 2 dudes hanging out that got scared away because of how the other individual was acting. And then the final seconds. So ladies and gentlemen, this is about a big picture. A situation that occurred for over 3 minutes. And the state just argued to you about not seeing him pull his firearm. His hand, you'll see it move right to his waistband. There. That is the point that this turned into a shooting. That is the point that this turned into a shooting. This moment where we saw on the camera when he was walking in the hallway, how he places his hand on his waist when he's touching his firearm. That's what you saw.